to Thursday afternoon webinar, and we are actually here this Thursday. We probably won't dwell upon the past too much. Suffice to say that, yeah, let's not dwell upon what happened last week. Let's focus on the future. I'm Chris Hynes, Strata Advisor, former Commissioner, Body Corporate and Community Management. With me, as always, every Thursday, Frank Higginson, partner, Hynes. Frank,
hello,
welcome.
everyone.
And as a very special guest this week, I'd like to welcome Nikki Jovakic. Well, I practiced it too, Nikki. Nikki
that
Jovakic.
was fairly good.
Yeah, Nikki Jovakic from LookUpStrata. Nikki, thank you for being here.
Thank you very much for having me today. Hi, everybody.
For those of you who are not familiar with LookUpStrata, it is an absolutely fantastic online resource, and the only resource that combines strata issues, strata queries from every state and territory in the country. And Nikki, you've got the LookUpStrata magazine out at the moment.
We have, Chris. We've been putting out a state-based magazine for most states around Australia, and there is one that goes out every month for Queensland. And we've had a great response from our audience for that, and it's packed full of particularly and only Queensland magazine strata information, and it's information that's not available on our website. So it's brand new Queensland information every month.
Outstanding, outstanding. Thanks. And as I say, if you want some more information about LookUpStrata or indeed Hynes, just refer to the details on the crawler across the screen, and we'll sort of get you in touch. Nikki's going to loiter away in the background today while Frank and I yak on endlessly. No mean feat. So thank you again, Nikki, for being part of today. Much appreciated.
Thank you, and I'll be sitting in chat if you have any questions. Thank you.
Awesome, awesome. I want to take a moment to thank our new viewers this week, of which I understand, Frank, there are quite a few. So hello, everyone. We'll try not to bore you too senseless. There are no special effects, but yeah, well, maybe there will be another time.
Some witty charm, mate. Witty charm.
Just to note that you can pose us comments and queries in the YouTube comment facility, and you can actually do that not necessarily just today. You can do it before, you can do it during, and you can do it after. So yeah, feel free to pose us some questions. We've already got some for today, so we'll get to as many of those as we possibly can throughout today. But today, Frank, we are talking about brand new strata legislation, which commences in, gosh, one working day.
1 and a bit business days. Yeah, absolutely. It, you know, and I suppose we've gone from regulation modules from 2008 to regulation modules for 2020. So it's a once in 12-year event. And interestingly, I think it's probably been the last couple of days, we've both been copying a lot of detailed questions, particularly from strata managers about what about this? Yeah. What about this? What do you think about this? Is this the way it works? So I think we're now at the pointy end of the conversation where everyone is looking at what the hell happens on Monday and how does this actually translate in practice? So the legislation might say a big global macro thing, but what does that actually mean? So it's going to be really interesting.
Absolutely. So I suppose the comment that we'd make right at the start is try not to panic too much. None of these changes are that earth-shattering, but there will be changes. Let's not make any bones about it. There will be changes to how things get done in strata world, and it's important to have a good grounding in what those things are. We're not going to go over every single change today line by line, just won't have the time or the bandwidth to do that today. What we're going to talk about largely, Frank, though, aren't we, is about some of the big ticket items that we've been picking up over the past 6 months. So you and I have been out there either as a dynamic duo or by ourselves, and we have been endlessly out there talking to people about these new laws. And we've been picking up some particular themes, haven't we?
Absolutely. There's certainly some focused attention on specific parts of it, some of it that doesn't actually seemingly matter yet. So I think today is more than anything else about those bits. So when we say last minute primer, I suppose, this is the stuff that everyone is on everyone's radar that might be of issue to them, which means I suppose it really is. It's what everyone's talking about.
And in a lot of cases, the laws commencing on Monday are confirmation of practice that's been happening in the industry for a couple of years in some cases. And the best example of that is about electronic voting and remote attendance. So that's now being confirmed as fine, because as I know you've been saying a lot lately, Frank, technically, up until this point in the process, it's not really been allowed, technically speaking. Yeah.
No, but everyone's been doing it. So you'd ask, how does that happen? It happens because what adjudicators have done is really allow people to participate in the affairs of their body corporate in the ways that they can. So I suppose when these things were drafted, 2008, I suppose the drafting process was 2006, the interweb, and even this type of technology wasn't available the way it is now. So as times evolved, in a sense, practice has got ahead of legislation. And you come back to the very macro parts of this legislation is about allowing people to self-govern and about allowing people to participate in the management of their community. So if the only way they can get there is showing up on a Zoom call or a phone call or a teleconference or whatever, adjudicators usually have sanctioned that because that's allowing people to participate when they might otherwise not be able to play. But now the legislation actually says that's lawful.
With an ordinary resolution agreeing to it. So it is important. There is still a formality that goes with it. It's not carte blanche. And there will be some buildings for whom electronic attendance just won't be the best option. That's just the nature of it. Probably the second thing that we'd say, and the second thing that's been emerging from us in our conversations, Frank, is the, how shall we put it, surprise and disappointment from people when they realise what's not covered in any of these changes. So some of the big ticket item, the really hot button topics that really grind the gears of people in Strata, not covered under these changes. So pets, towing, Airbnb, smoking, scheme termination, not covered in any of these things. People are eager for those changes, and without going into too much detail, Frank, you and I this week have been involved in a couple of meetings to hear about how those issues might get addressed in the next 12, 18 months, 2 years.
Well, the start of the process. In terms of what those changes might look like, who knows?
Start of the process is important though, isn't it? And to be involved in it, equally important. So all we can do for the moment is just to say, stay tuned. And we're going to talk about that process and what's involved in it, I dare say, quite a bit as the rest of this year goes on. For now though, let's talk about what you need to deal with from Monday. One of the interesting things to emerge, Frank, in our chats is the idea of quorums and about how people are a bit confused about quorums, what they are, what they do, and how they work. And then also what the change is. So Frank, what's changing on the quorum front?
And it is, you look back at this, so I suppose if you go, again, macro level, a quorum is the number of voters that must be there to allow a meeting to start. So first thing to remember, and there's part of me that probably looks at this and goes, this is just insane in terms of why we've got these two thresholds, because a lot of people confuse quorums with the number of lots. So at the moment, until Monday, well, I suppose Monday the rules are still the same, to have a meeting, a general meeting start, not committee meeting, general meeting, you need 2 people there present in person and 25% of the voters having cast a vote. Now that's not lot owners, that's voters. So if we're in a scheme and there's 100 lots and one person owns 50 of them, that person has 50 votes at general meeting, but they're only one voter for the purposes of calculating a quorum. So that's first concept. So it's a really difficult thing, and we've certainly had some feedback, Chris, from Strata managers in terms of counting quorums and all that sort of stuff, in terms of that's the trigger to start a meeting. If you don't have a quorum within half an hour of the start of a meeting, it's held over to the same bat time, same bat channel next week, and then whatever's there is whatever's there. The new regime, and so I suppose those adjourned general meetings happen quite a bit. So it's very common for there not to be 25% of people as voters participate in the affairs of their body corporate. So back to that hypothetical 100-unit building, if we don't get 25% on the first week and the next week we've only got one vote, that's what it is. That one person is effectively exercising, I suppose, presidential control over their particular building, whether they're on the committee or not. What the regulations are going to allow from Monday is for a body corporate to change its rules around quorums. So the first change is it will allow the body corporate to decide that a quorum only needs one person present, and that person will be able to be present electronically, provided that the body corporate's also resolved to allow that to happen. The second part of a quorum is being able to reduce the 25% of voters down to no less than 10. So it could be 13%, it could be 15%, and it's an and or. You don't need to have both. So I suppose what we'll see out of the back of this is going to be a bunch of bodies corporates decide that maybe they want to get rid of adjourned meetings, and they'll tweak their quorum requirements to allow, I suppose, lesser number of people to allow a meeting to start, so decisions to be made. So there may be less adjourned meetings, and there may also be squeals of outrage about people not having their chance to vote because they thought they had more time. I don't know. It's a really interesting one. So
just going to post a link here, Frank, to the benchmark case for quorums, certainly as it currently stands anyway. This might change under the new regime, but the current benchmark case is for a case called Sierra Grande, and that link should be up there shortly. Yes, there it is. So that is the gold standard benchmark for quorums and quorum calculations for bodies corporate in Queensland. So yeah, that's definitely been something of considerable interest to people. I think also insurance has come up a couple of times in our discussions as well. So the change for insurance is that committees will be able to spend above their spending limit if it's to renew the policy or to put into place a policy. They still should try and get 2 quotes if they can, which would be very difficult in some parts of the state. What's been interesting though, Frank, is the number of committee members who have talked about what responsibilities they have in terms of disclosing the kinds of offers they get for insurance, hasn't it? It's
a really interesting one, this one. This has certainly been of concern to a lot of people. And it really is that function of what are you there to do as a committee, and how not accountable, I suppose it's transparent, how much you have to communicate or should communicate with all of your owners about what's going on. So I suppose my take, as has always been, is that you're there as a committee member, so your job is to act in the best interest of the body corporate. Provided you do that, usually you're above sanction in a sense, but in this environment, and particularly with social media and the ability to communicate things quickly and effectively, sometimes I think even if you are making those decisions, I think it makes a truckload of sense to communicate them to owners, particularly if they're going to be of importance to owners. So one of the ones, Chris and I were talking to someone this morning, or a group of people this morning, about alternative insurance. So again, for a lot of lot owners in North Queensland, insurance has become a real battle, and to the extent that they might not be able to get the level of cover that they're required to at law. So you might have a building with an insurable value of 10 million, and you can only get 5 million worth of cover. So what do you do then? So if you've only got that particular option, the next conversation is, well, do we get that approved at general meeting? And certainly the commissioner, when she approves them, will require notification of owners in some way. And it's not so much, I think, approval at general meeting. It's a matter of communicating to owners pretty much straight away, Houston, we have a problem, and this is what it is, and this is what we're doing about it, and this is what we've done. And the inevitable, if you want to get involved in helping solve the problem, you can put your hand up to get on the committee.
Absolutely.
Because that's the immediate spear that'll be thrown at you.
For sure. We spoke about electronic voting before, and probably the interesting part to note, apart from the fact it will require an ordinary resolution to give effect to it, but I think the new legislation makes specific reference to the fact that any electronic voting system must be able to ensure that no one gets to vote twice. Seems pretty fair and logical to me.
Unlike every other election we can participate in.
Yep, but also needs to ensure that secret ballots, the integrity of the secret ballot is maintained. And our understanding is that most software systems have already got that well in place and well in hand, but it might pay for committees and managers just to make double sure that their systems are all set up around that one, because the last thing that you want is for a secret ballot to go awry because something occurred with the technology. And remember, something is a secret ballot under body corporate legislation because it's significant. Minor things do not generally go to a secret ballot. So I suppose that's more a reminder than anything else. Just make sure those things are accounted for.
And certainly the practice with a lot of and a conversation with a client this week where a secret ballot would actually help this particular committee to get where they need to go. And so I checked with the Strata manager where they're up to on it. And their response was, we're road testing it all with our smaller buildings first to get familiar with it before we unleash it on the bigger ones, which does make some sense. Get some trial and error out of the way, because it will be interesting. And actually one of the Strata managers who's probably watching this had a really interesting observation about secret ballots that can be conducted in paper and electronically. So if we had a secret ballot where 10 votes came back in electronically and one person went to the meeting and voted in paper, which way they voted is abundantly clear. So that, in that sense, there's an issue with secret ballot where the identity or the voting intentions of the voter aren't protected. But anyway, that's not in the legislation. So
that's right. One of the more interesting features that have popped up is the concept of debtor members. So the current situation is that you can be on a committee and owe a body corporate debt, so your levies aren't paid or there's an amount of money outstanding, and yet you still get to vote as part of the committee. Whereas, of course, if you're not financial, you don't get to vote at the general meeting. So that has been changed from the 1st of March. If you are a so-called debtor member of a committee, you will not be entitled to vote. You will be counted for the purposes of quorum. So we go back again to the idea of a quorum being the minimum number required to get it started, but your vote will not count. And Frank, one of the points we've been impressing upon people is that that needs to be taken into account for the committee meeting, but also votes outside committee meeting and for nominators as well.
Absolutely. So one of the things, again, the legislation tries to encourage is self-nomination. So it's Frank nominating Frank to go on committee. It's not Chris nominating Frank, because the way these new provisions work is that if Chris nominates me and then Chris is unfinancial, then I can't vote, even though he's not on the committee and I am. So I think the practical side of things from a body corporate perspective, and I suppose, Chris, we've been bouncing around in terms of where responsibility for this sits. And so certainly there'll be fingers pointed at Strata managers to the extent that they send out a VOC and people are voting on it when they're not financial. But it really does come back to the individual committee members as well to make sure that they've paid their levies.
Yep.
So, but that's going to be a really interesting one, because I mean, a lot of buildings might have quarterly meetings, but then they have VOCs every other day about pet approvals, about improvements to lot owners' lots, or whatever it might be. Just it's another thing from a compliance perspective to have to check off to make sure that the committee decision is actually a lawful committee decision.
Definitely. One of the other big changes that's coming into effect from the 1st of March, from Monday, is the concept of owner motions for committee. So let's be clear, we're talking about committee meetings here. We're not talking about general meetings. Your right to put up a motion to a general meeting if you're an owner is unchanged. What we are talking about here, though, is the idea that you, as an owner, have a right to submit a motion to a committee. So that right has been confirmed, but some restrictions around it, Frank, haven't there?
Yeah, absolutely. And so for those of you that want the long-winded detail, go back to January, I think, on our webpage and have a look at the webinar Chris and I did on this. And again, and this is one of the things that's been interesting for me and will be interesting in the context of the working group and the review of the legislation, is when you sit there and have conversations with the people who are actually drafting the legislation and government and industry groups and all that sort of thing, there's a bunch of broad policy principles, I suppose you might talk about. This is what we're trying to achieve. And then there's the constant accusations, of course, that we always get about living in a nanny state. So to me, this section of the module is a prime example of trying to find that balance. So what it does in macro terms, again, is give owners up to 6 motions to the committee in every 12-month period, which the committee must then decide. Because previously, as much as the only argument you could really fall back on if you were an owner writing to the committee with a motion is, I want you to consider this, and the committee in effect could ignore it, because there's no obligation on them to consider it unless you consider it's reasonable for them to do so. So that was the argument you had. Now that argument's gone away. So you've got, owners have a statutory right to submit. Committees have a statutory obligation to consider. So if an owner submits a motion, committee's got to decide on it within 6 weeks. They can extend that by another 6 weeks if it's reasonable to do so. And Chris, I think probably we've had lots of questions about what's reasonable in those circumstances. What we think definitely is not reasonable is where we're having our next committee meeting in 10 weeks' time, so you can wait till then. That's not a reasonable basis to say no. A reasonable basis might be you've asked for a very specific question about some type of improvement that we need to get some engineering advice on, and we'll come back to you when we've got that.
Yeah, that's perfectly fair.
Yep.
Simply because the applicant has a desire for it to be dealt with quickly might not necessarily be of itself reasons one way or the other, I should add. And there is an onus upon owners to make sure that they get motions in the right time frame. And the classic example of that is wanting to move into a scheme tomorrow with a pet and asking for approval for it today. That's
back because I don't want to do this solo. Oh, there you are. Mate, you froze there for a minute. Panic.
No, definitely here. But yeah, there's give and take on both sides of that. We had a question from Kim. Kim, thank you for your continued interest. Kim asked if there was any kind of template that had been created to cover. No, actually, wrong question, Kim. Sorry, disregard. We'll come back to that one. There's too much going on. Speaking of questions, there's a few questions that have come through already. I might just take the first one there. Edward, thank you for tuning in. Why is it so difficult to live in a community? Because people are people, Edward. That's why. Because everybody's got an interest that they want looked after and furthered. If everybody was the same and nobody had any competing interests, there would be no problems. That's a very simplistic answer, but that's pretty much it.
And I think, Chris, a really good analogy that Chris has used as we've been running around, because that's not the first time we've asked that question either, is that body corporate 30 years ago might have been 5 people getting together to have a beer on the driveway with some cheese and bickies and making some decisions, and away you go. That's not what it is anymore. Running a body corporate and being on a committee is actually running a business in a sense.
Yep,
it's not just a body corporate can't run a business legally, but it can be, particularly for the bigger schemes, running a massive enterprise. With tens of millions or hundreds of millions worth of dollars, with maintenance contracts and all sorts of things and other financial arrangements and responsibilities. That is.
Still with us, Frank? Frank has frozen this time. So look, I will
balance there where the legislation has to create a set of rules which people must abide by, but by the same token, these things are getting more and more complicated, which potentially creates the need for more rules. So it's great for us as lawyers. And one of the things we try to do with these webinars is help people cut through some of it to understand it more, but it's never going to get simpler.
That's right. I might move to the topic of same issue motions, because we did have a pre-webinar question about those. So currently we have a situation called motion with alternatives, where if you have a similar lot of motions all together at a meeting, you had one initial motion, which is an above the line. I think that's the analogy you've been using a lot, Frank. Yep. And then there are 2 options below the line. So you either vote yes or no for the first thing above the line, and then you vote for one of the alternatives. That is finishing, that arrangement. From Monday, we'll have what are called same issue motions. And the way that works is that, let's just say 3 owners submit 3 motions on the same topic. They must be considered as a group together. All those entitled to vote can vote yes, no, abstain to 1, 2, 3, or none of them for that matter. Then it's a process of elimination as to which one wins. So if only one of those 3 motions has the correct qualifying threshold achieved, that's the winner, isn't it, Frank? Then you go down to what has the most number of yeses. If that's still a tie, least number of no's. If that's still a tie, game of chance decided by the meeting. So to me, it's a fairer, logical scenario, Frank. I think that's generally people are agreeing with that, aren't they?
I think so. It's just a matter of getting used to the way they've got to be presented, because we've been running with the old alternative motion regime for 12 years. And of course, the other big difference is that on the alternative motions, if you voted no above the line, so again, the example we've been using is a fence. We're going to do the fence in brick or the fence in wire. So the way it used to be structured is that the body corporate build a fence. If you voted no above the line, you weren't able to have a choice about which type of fence it was below the line. So now, if you don't want either of them, you just vote no to both. So it actually sort of empowers people to have more of a say.
Definitely. And so Kim's question, now I've got the right one, Kim. Kim's question is whether or not there's any kind of templated form which is going to advise on that process. The answer is no, there's not, Kim. And it will definitely be up to committees and body corporate managers to ensure that people know what it is they're meant to be doing. And that could be as simple as pointing people to a webinar or some information online about it. Or it could be something a bit more involved, such as when you get to your first agenda where you have your first lot of same issue motions, maybe just a little text box in there saying, please note, this is now what is called same issue motions. This means that you do the following, whatever that might be. Play around with that wording, test it, and run with it and see what works. But yeah, particularly if you've got a building where you know that that's likely to be a problem, worth the while, I think, spending a bit of time to get that right. We are fast running out of time, so I'm just going to hop down, Frank, to, I think I'm going to go down to the calling nominations from the floor, because we've got all manner of fascinating questions about this one in one particular seminar that we attended. So what is going to be required for Monday on that one, Frank?
So the committee, unless you're in a PBC and you vote to increase it, so for 99% of people out there, your committee is going to be a minimum of 3 people and a maximum of 7. So what the legislation now requires, and this was sort of interpreted by adjudicators to suggest is best practice, and again, this is reflecting probably what most people do, is if we have, so the way it works at the moment is there's an invitation that goes out to your body corporate 6 weeks before the end of the financial year to say, hey, if you want to nominate for committee, here's your chance, and if you want to submit motions, here's your chance. And if you're in by the end of the financial year, then potentially you're either elected unopposed, if no one else is nominated for chairperson or otherwise, or there's a ballot for your position. So if 2 people nominate for chairperson, one's going to win. But if you only had 4 nominations and there was no competing ballots, you come to the AGM, those 4 people are automatically elected unopposed. What the body corporate's now required to do is to ask people who are at the meeting on the day to say, okay, we've got 4 people in these spots. We have got 3 positions left. Would anyone like to fill them? And actually invite nominations from the floor in that sense. And again, that's back to encouraging people to participate. And clearly there's some people, because of the delay between the end of financial year and the AGM, which is normally going to be 3 months, some people might have settled the purchase of their lot, weren't able to nominate before they closed, before the nominations closed, and they're there at the meeting, they want to play, they've got to be invited to participate. And probably, Chris, the other one then was really a lot of questions about casual vacancies. This is something that I think a lot of people don't understand, as much as this hasn't changed under the regulations.
And I think what's happened is, in talking about committee membership, people's minds have turned to that topic, and there seems to be a fair bit of confusion about that idea. We're actually going to do a standalone webinar in the coming weeks about getting on and leaving committees and the various ways that that can occur. But suffice to say, there is no change to the way in which casual vacancies on committees have been filled. In the short time that we have left, I just want to address a couple of questions there. Question there from Lucy. Oh, question from Ian. Any changes to the code of conduct? No. How mandatory is it? It still applies. Is it worth the paper it's written on? Debatable, but there's no changes to it. Ian? No. Edward thinks that strata managers should be minimal lawyers. I think what you mean there is, at a minimum, they should be lawyers. To which my response would be, sure, Edward, do you want to pay the extra money that will inevitably come with that? And perhaps if you don't like managers, then perhaps you could manage the scheme yourself and look after your investment that way, which is designed for you to do so. Lucy, a motion submitted to an AGM to change bylaws that will include roles and responsibilities of committee members. Is that out of order? If a bylaw puts obligations that are different to the obligations of the Act or more than the Act, chances are, Frank, that'll be out of order, won't it?
If it's unlawful or unenforceable, absolutely. So I don't think you can have a bylaw that would say the chairperson must do this, or the chairperson can't do this. What the chairperson can or can't do is set out in the regulation module. So to the extent that bylaws try to change that, I'd suspect that they probably are unlawful, which means they should be ruled out of order.
Might just hop down to a question from Yana. Yana, thanks as always for tuning in, because it follows up the committee question that Frank and I were just talking about. What happens if there are two people for the same position putting up their hand from the floor? Is it a vote from the floor?
I think so. Have to be of those people that are there on the day. And I suppose now that, assuming the body corporate's allowed electronic voting, it's going to be the people that are participating in the meeting electronically as well.
Yep. What I would suggest in that case, Yana, particularly if it is known in advance of the vote that there might be one or two people competing for the same position, there's nothing stopping from some discussion before the meeting. That's absolutely fine between the parties who are running for the same position or the manager or the rest of the committee to say, hey, listen, it looks as though you two will both be putting your hand up for this. If it is tied on the day, it's going to go, it will be subject to a show of hands from the floor, for example. Just letting you know that. Just giving people the chance to think about, do they want to have a discussion about it? Does someone want to gracefully step aside? That can happen. I know that sounds weird, but it does happen,
Or go through the public shaming of getting absolutely belted in the numbers.
Am I being too utopian there, Frank?
Oh, it's possible, mate. You aren't always a cynic.
Couple of comments there from Michelle and Edward complaining about the commissioner. Well, as a former commissioner, I think that's very unfair, and I think that's wrong, frankly. And I know that at least one of the commenters have had an order go in their favour in the past from the Commissioner's office. So to say it's a total waste of time is actually factually incorrect. My general response is that you get out of the Commissioner's office what you put into it. And I'll just leave it at that.
And mate, I would add to that, and this is the thing, it's quite interesting. I'm part of a national organisation of strata lawyers. Queensland has a very unique jurisdiction with the Commissioner's office where people can actually ring a free call number and ask experienced people, what should I do? Where do I go? And actually provide information. If you live in any other state of Australia, there is no information service like that. You're spending time on Google, on Austlii. You might ring the Office of Fair Trade in New South Wales that might give you some answer that might relate to your question or not. So it's actually a spectacular resource that is not available in any other jurisdiction. So, because if you didn't have it, you are completely on your own. And then you're paying people like us to give you advice. So from my perspective as a public service, I think it is good. Everything has its drawbacks, don't get me wrong, and they can't give legal advice, they can give information. So you're not going to ring up and get an absolute answer, but in relative terms, compared to the rest of Australia, it is a spectacular resource.
And look, we have run out of time nearly, but I just want to very, very quickly touch upon the power of attorney change, Frank. So we are going to do a standalone webinar on powers of attorney, proxies, representatives and nominees in the not too distant future. But Frank, just really quickly run us through the power of attorney situation.
Yep. So BUGTA comes up again. Under BUGTA, there's no regulations about proxies. When BCCM arrived in 1997, they really capped proxies. So proxy is another way for people to be able to represent themselves if they're not capable of getting to a meeting. Proxies under the regulation modules can't be used for certain things like voting for committee. Bodies corporates can prohibit them absolutely, and there's also caps in terms of percentages of the proxies that you can hold in any particular scheme. There were no restrictions on powers of attorney. So powers of attorney could be limited. So the normal power of attorney that you might think is an enduring power of attorney you give to your spouse or your partner, where they can turn the switch off on you or administer drugs or take all your money and go to bank accounts and whatever. You can also do limited powers of attorney that relate just to particular purposes. And so one of the things that probably was abused in a sense, Chris, was people were appointing an individual to go as an attorney to vote at general meetings and effectively
Who would
controlling
do
the
such
votes.
a thing, Frank?
People would throw that stone at me, but anyway, I went to one meeting with 88 of them, but there you go. That's
good on you for putting your hand up, by the way, Frank.
I'll own it, mate. So now powers of attorney are capped at 1, unless you are a family member of the person giving it. So my parents own 3 lots, I could hold 3 powers of attorney, but other than that, I can only hold 1. So bang, gone, end of story.
And let's just quickly remind everybody, a power of attorney is not the same as a proxy.
Definitely different.
And it's not the same as a representative or a nominee either. So let's just make that point clear. We have come to the end today. Thank you so much, everybody. We've had some great responses today, great engagement. Thank you so much. I think what this tells us is that people are keen to see what the new environment will look like, but they're also keen for the information in kind of this very practical, hands-on way. So, and that's what you will get from us each week. So that's what we will deliver. Thanks again, Nikki, very much for moderating and hosting there in the background. If you get a chance, please subscribe to our YouTube channel. That would be awesome. It's a good way of getting some feedback about the kinds of topics. And if you do have any ideas, suggestions, or requests for topics, please let us know. We can incorporate that. Speaking of topics, we will release the topics for March next week, because it happens to be March next week. So we will release the topics next week. There's some good ones in there, I can assure you. We'll also release some material following up this webinar next week as well. So just a bit of additional material to follow up this webinar. That'll be coming out to you next week. But for now, Frank, it's been a pleasure.
It was good to get going again. Yes. So thank you everyone for joining us.
Yeah, thank you. And we really do appreciate it, everyone. Thanks for coming along. We'll see you next week. See you, everyone.